Today, more and more states fully recognize the fundamental constitutional right to carry firearms for self-defense. But can you imagine a world where the government actually tells you that you have a legal obligation to carry a gun in public? Well, in many situations in the 18th century, the start of our country, by the way, early American colonies and early states did exactly that. Now, why does this matter? Well, these laws are further evidence, historical evidence, that the Second Amendment protects a right to carry arms in public, just like it says it does. More on this when we get back. Hey folks, I'm Mark and welcome to the Four Boxes Diner. As you probably know, the United States Supreme Court is hearing a very important Second Amendment case called NYSRPA, or New York State Rifle and Pistol Association versus Bruen. And in that case, the Supreme Court is going to decide whether the Second Amendment protects the right to carry guns outside the home for private self-defense. Going back to 2008, when the Supreme Court first found that the Second Amendment protects an individual right to armed self-defense, the court looked to early American colonies and early American colonial and early state history and traditions to reach that decision in Heller. Now, how people, including the founding fathers, actually lived their lives, their lived experiences, if you will, at the time that the Second Amendment was drafted and adopted and ratified in 1791 was very important to the Supreme Court in deciding what rights you and what rights I have under the Second Amendment. So why was that? It's because that history helps teach us what the people who adopted the Second Amendment understood it to mean. Now, we've been going through the historical evidence supporting the view that the Second Amendment applies outside of the home. Now, this historical evidence clearly shows, in my opinion, that the Second Amendment protects our right to carry firearms in public outside of the home for self-defense. Of course, the anti-gunners argue, and are arguing in the Bruen case before the Supreme Court, that it was largely illegal to carry guns outside the home, or that it was at least heavily regulated by local authorities. Now, this argument by the anti-gunners ignores some critically important historical evidence. You see, the fact is that the laws adopted by many colonies and early American states actually required, I repeat, required ordinary citizens to carry their guns in public. Now, we know that some states today effectively ban law-abiding Americans from carrying any firearms outside of the home for self-defense. This is why the pending Supreme Court case of NYSRPA, or New York State Rifle and Pistol Association versus Bruen, is so important for millions of Americans, especially those millions of Americans that live in certain blue states like New York, California, and Hawaii, and New Jersey, among others, for making sure their rights are respected going forward under the Second Amendment. One of the things that will be important for the Supreme Court is looking at early American colonial history. And in my opinion, our history strongly supports the right to carry guns outside of the home under the Second Amendment. Let's discuss just a couple of examples here. First of all, take a look at 17th century Virginia. You see, 17th century Virginia actually required their citizens to carry guns outside the home when they traveled, when they farmed, or when they went to church. Rhode Island required their citizens to be armed when they traveled or they went to public meetings. And of course, there are many other places, including states like Connecticut, South Carolina, and Georgia, all of which, I repeat, all of which also required their citizens to bring their guns outside of their homes to places like, for example, church. We and the Supreme Court itself can learn a lot from these colonial era laws. These laws show how common guns were for the founding generation. Not only were firearms common, but it was common for states to require their own citizens to obtain their own guns and to carry their guns outside of the home to protect themselves, their families, and the community at large. The fact that colonists were obligated to carry guns in public shows just how ridiculous the anti-gunners' arguments are before the U.S. Supreme Court in the Bruen case. It simply cannot be true or make any sense at all that carrying guns in public was banned or even frowned upon at the time of our founding. This argument, as I see it, borders almost on absurd, right? Hopefully the justices on the Supreme Court will see it the same way. And hopefully the Supreme Court will confirm, as it was always understood during colonial times, that the Second Amendment recognizes and protects the rights of Americans to carry guns outside the home for self-defense. So thanks for joining me here at the Four Boxes Diner, where we serve hot, fresh Second Amendment news and analysis. And if you like what you heard, please subscribe and help spread the word. I really appreciate that. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.